Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On April 18th, 2025, in a 17-page ruling on multiple motions in Limine, the court at page 12 rendered a ruling on the state's motion in Limine regarding alibi defense. It says here the state moves to preclude defendant from offering any evidence in support of an alibi other than from the defendant himself. The basis for the state's motion is defendant's failure to comply with the notice requirements governing alibi evidence pursuant to IC, this is a statute, section 19519, subsection 1, and ICR 12.1, that's a rule of court, ladies and gentlemen, dealing with alibi. If requested by the state during discovery, a defendant intending to offer an alibi must file a notice listing a specific place or places in which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. End of quote. The court has the discretion to exclude testimony of any undisclosed witness offered as to a defendant's absence from the scene of the offense, citing to the statute again, 19-519, but this time subsection 4. The court then, in the next paragraph, cites to various sources and legal authority, including from Black's Law Dictionary, which is used frequently by judges and attorneys. And it is defined here, an alibi is a, quote, defense based on the physical impossibility of a defendant's guilt by placing the defendant in a location other than the scene of the crime at the relevant time, end of quote. Going on to the next paragraph at the bottom of page 12 going into 13, the court writes, at this point, defendant has only provided notice that he was out driving in the, quote, early morning hours, end of quote, of November 13th, 2022, throughout the area south of Pullman, Washington, and west of Moscow, Idaho. He intends to present testimony by his expert, Cy Ray, to, quote, partially corroborate his alibi using CSLI data from defendant's cell phone. However, the alleged offense occurred between approximately 4:07 a.m. and 4:20 a.m. At most, Mr. Ray can opine to where defendant's cell phone was up to 2:54 a.m. when it was apparently turned off, and approximately 4:48 a.m. when it began reporting to a network. Defendant has provided no evidence as to his location at the time of the crime. In other words, he has provided no alibi evidence as contemplated by the rules. Next paragraph. That said, the court will not categorically preclude defendant at this point from offering alibi evidence at trial, and citing to State versus Juarez. This is an appellate court ruling out of Idaho, and it states here whether to exclude late disclosed alibi evidence requires weighing prejudice to the state against the defendant's right to a fair trial and considering whether less severe remedies are sufficient. The court continues, there are still 4 months until trial begins. If defendant does unearth alibi evidence, it is his obligation to immediately make the state and the court aware of it. Excluding it at this time is premature, and therefore the motion is denied, subject to being re-raised if defendant does disclose alibi evidence. However, at this point, defendant has not provided an alibi partial, or otherwise. This will now conclude this episode of the Indie Zone. My name is Kathy. Thanks for joining us here today.